On that basis, I certainly support the passage of this bill.
Julianne Gender.
Tēnā koe, Mr. Speaker. Very pleased to rise to speak on the Sentencing Aggravating Factors Amendment Bill. The Green Party will be supporting this bill. It is a short bill with a perfectly reasonable aim. As we've heard, it seeks to ensure that an offence committed against a police officer or a prison officer acting in the course of their duties can be taken into account as an aggravating factor at sentencing. And, of course, it was decided by this House to include emergency health professionals, fire service providers, as suggested in Charles Chevelle's supplementary order paper. We supported that move as well and believe it did add to the bill considerably. That said, I'd like to take this opportunity to raise some issues regarding this bill. First of all, there is actually little practical justification for it. Essentially, what this bill provides for already occurs. My colleague David Clendon specifically noted what the Crown Law Office had opined in its review of the bill, which I think is worth repeating. They said that, and I quote, New Zealand sentencing decisions take into account the fact that a victim of an offence was a police officer or a prison officer, acting in the course of his or her duty as a matter of established practice. This bill confirms the common law position. So, although we find it to be a slightly unnecessary piece of legislation to pass through this House, we have opted to support what is the judicial practice of the day. Because not to support the bill would be effectively be a vote of unconfidence. It would be a vote against what is currently happening. Rethinking Crime and Punishment observed in their submission on this bill that there had been no evidence put forward that showed a significant increase in the number of assaults on prison or police officers. Although, had there been an increase in the number of assaults on prison or police officers, that would have been cause for immense concern. But the lack of evidence does call into question the practical justification for bringing this bill at this point in time. Why is this the priority? Are there not other more effective things that the government could be doing with their time? Seeing as this bill is here, however, we would have also liked to see a couple of additions to it in order to increase its scope and potentially its fairness. So, as my colleague David Clendon has said, while it does no harm in its current form, it could do some good if these had been more fully considered. Firstly, although we agree and commend the intention to recognise the worth of police and prison officers and denounce offending against them, and I have to acknowledge the excellent comments made by the Honourable Leanne Dalziel right now, just previous, that in fact it would be erroneous to believe that the aggravating factors would be, and sentencing would be, result in any deterrence. There's simply not the evidence to suggest that, and so we wouldn't want to conflate that reason, deterrence, with the reason of denouncing offending against the important work that is done by prison officers and by police officers. So we simply do not see that it actually enhances their protection. Greater resources and more legislative emphasis on crime reduction has a much greater proven capacity to increase the security of society as a whole, and we would be better served, I think, to focus on these measures rather than the very narrow scope of this particular bill. This would require, of course, a much more concerted effort, however, and I accept that this bill could not possibly deal with it on its own. But for all that, it could make some effort in that direction. In terms of fairness, the bill essentially enshrines the interpretation that offences against specific public servants in the line of their duty ought to be treated more severely by the courts. There's certainly an argument to be made, given that all we do in this House to acknowledge the importance and worth of police and prison officers. However, we should note that with the protection of those in a position of authority, there should be a similar and equal responsibility. And we call this reciprocity. Police and prison officers most certainly fulfill an important function and serve in a position of authority. They are often placed in harm's way and they deserve protection against that harm. In turn, if they are found to have committed an offence, we might consider it only fair that their actions also be considered an aggravating factor in their sentencing, should it reach that point, on the basis that their position of authority bears that very significant level of responsibility. If their rights are enshrined within the law, so too should be their responsibilities. I also mentioned earlier a matter of scope, and I'd like to turn to that now. The New Zealand Public Service Association made the point in their submission that there are a wide range of hugely important public sector roles that will not enjoy the protection or recognition that this bill contains for police and prison officers. So we are pleased that the bill has been extended to include emergency health and fire service providers, but there are still plenty of public service providers who are left out. Mental health workers, social workers, noise control officers, paramedics, ambulance drivers, I think actually ambulance drivers might be included, animal control officers, fisheries officers, name just a few of those who aren't going to be included. And they all perform a vital public service, and they run the risk of harm to their person during the performance of their duties. And the submission said, and I quote, that PSA workers in a range of frontline occupations, including ACC, customs, and social workers, are regularly subject to assault. So while this bill does not necessarily diminish their worth, it certainly does nothing to advance it. We would have liked to have seen a much broader brush applied with this legislation, always keeping in mind, of course, the principle of reciprocity. So despite the issues I've raised, I would like to emphasize again that the Green Party will be supporting the bill. It does no harm in that it simply enshrines in law what was already happening in practice. But it also represents a lost opportunity. There is a lot of time and effort that goes into preparing, considering, and progressing a bill, however short it is. And we firmly believe that time could have been better spent genuinely advancing the protection of police and prison officers, or broadening the scope of aggravating factors to include the vocation of a wide range of public service roles who similarly encounter the threat of violence in the performance of their duties. We owe a duty of thanks and care to them, just as we do to prison and police officers, and I hope that in the future we do not leave them out. Thank you, Mr. Speaker.
Call Jami-Lee Ross.
Mr. Speaker, this bill makes some very welcome changes